mbali nami. Ukweli ni kuwa uliposema hutaniacha kamwe, hivyo tu ndivyo unavyotenda. Na hulali pia waniwaza. Baba, nipe uvumilivu, uvumilivu. Baba, nipe uvumilivu, uvumilivu. Siku zangu zote nikungoje. Uvumilivu, uvumilivu, uvumilivu. Yesu, nitakungoja Yesu, nitakungoja, 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 ninakungoja Yesu, ninakungoja, 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 nitakungoja Yesu, nitakungoja, 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 ninakungoja Yesu, ninakungoja, 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 nitakungoja Yesu, nitakungoja, 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 Baba.
Good afternoon and welcome to today's session of Midweek's Vibe. We're really excited to be coming live to your houses or to the office. If you're on the roadside, still okay, using your phone, karibuni sana. As usual, it is our delight to have you on board. Last week, we talked about wills. We defined what the will was, the importance of having a will, and the council here helped us address a few of the questions that pertain to will writing. And today, we are glad that they are back on set to carry on with the process. Today, we want to deal with the issue of intestacy. Yes, I got it. Yes. And what is that? That happens when you die without a will. And we know on books, in essence, you should have a will before you die. But we know there are many things that come along the way. Maybe you decided to die at 90 and the Lord has whipped you before then. Or you made a will that was invalid. Or better still, culturally, you thought, if I die with a will, I am invoking death. And so for that reason, Sifani will, the council will be able to help us know what happens in that case. And before I get out of tune with myself, I want to introduce the cast. And now, as usual, I will start with my co-host, who has been a host for the longest. And today she has decided to pull a fast one on me to introduce herself and go ahead and introduce our friends. Karibu sana.
Thank you, absolutely. Asante sana, Eunice. My name is Jasmine Wangai, and as usual, very excited to be here today and to continue with this topic that we started last week, which I think is very important, especially for our context that we are in. And of course, Eunice mentioned that we have a team, a very able team who were with us last week, and they're back today as well to help us continue with this discussion. And I'll invite them, just for anyone who is new here, to introduce themselves so that we get to know them before we continue with our discussion. And I can start on my left here. So karibu.
Thank you so much. My name is Ruth Nyambura Kibebo, an advocate of, sorry. My name is Ruth Nyambura Kibebo. I'm an advocate of the High Courts of Kenya. And we were here last time discussing wills and intestate succession. And we are glad to be back to discuss intestate succession. So tune in.
Karibu.
Karibu.
My name is Jerry Gitonga. I'm an advocate of the High Court. I'm also the general counsel or in-house counsel at Akili Kids TV. And I'm happy to be back. And thank you for inviting me again.
Thank you so much. And one of the things that makes me glad is that we have been able to get congregation members to come and offer your time and your knowledge and wisdom in this area. So we are really, really thankful and do not take that for granted. And we, as we said last time, we want to say again, may the Lord indeed himself bless you in abundance
Yes.
for what you do for us and the congregation members.
Indeed.
And karibuni sana.
Indeed.
Thank you.
Indeed. And to continue with our first question for today, I think Eunice and Ruth here have used a very big word. That it's probably prudent to first break it down and tell people in English, you know, I do not know what that language, in English, what is innested, being innested? I was about to say something else. Intestate. You see, I'm even lost.
We excuse you, Jasmine.
Thank you
We
very
appreciate
much.
that you're a pastor, not a lawyer. You're excused.
Pardon me. Yes. What is being innested? Intested.
Thank you.
You know, I'm done. Okay, that word.
Just look at me and I'll say it for you.
Okay.
It's intestate
Intestate.
succession. Intestate succession is the process of distribution of the estates of a deceased person where there is no will. Yes.
So it's about a person who passed on. There's property that was left behind.
Yes.
That process of
Yes.
claiming is what we describe as
Yes.
intestate.
Yes,
I got it
intestate
right this time round. You know, as we continue with that, we definitely have our first question when it comes to that. So when it comes to such a situation where there wasn't a will that was written, but there's property left behind by the deceased, what's usually the order of priority in terms of distributing this property? You know, and I'm thinking of a scenario where this person wasn't married, doesn't have children. What happens in that situation?
So if somebody like that passes away and they didn't leave a will, then under the law of Succession Act, there is an order of priority that has been established. And so in a scenario like that, then you have to look at his who are his most immediate family members. So if there's no wife and there are no children, then you look at the parents. So for the parents, you look at the father. If the father is there, then he will be the one who will inherit the property. If the father is not there, then you go to the mother.
So the inheritance isn't the parents, not just
No,
the
no.
parents. You start with the father first and then
Yes.
mother second.
Yes. And since I'm in a panel of 3 women,
This is it's not feeling right somewhere. In
I
light
want
of
to push that
2010
point, right?
Constitution, I know.
Ruth, do you have a comment on that?
I think I won't comment on the issue of who amongst the parents would take, priority. But I think what council has stated is that the law of succession actually lists down people in order of priority for inheritance where someone has passed away without any direct or dependents like children and all that. And I think that is clearly stated in Section 66 of the Law of Succession Act. And it states that we have, like Council said, there's a surviving spouse, there's the parents, then of course siblings and step-siblings. Then we get down to there's also the public trustee. And then down there we have the creditors.
So wait, what's the role of the public trustee here?
Public, yes.
They are listed
Yes, they are listed.
as a potential beneficiary or as who?
Normally, I think because we do not want to delve into a topic that is outside this discussion, we have people who pass on and they do not have, people who claim their estates. So normally you will find that the public trustee actually does petition
I
as
see.
the administrator.
I see.
And it actually proceeds to even distribute the property. Yes.
Yeah.
Yes.
Okay. Okay. All right. You wanted to say something else.
No,
Both of your mics
anyway,
are super ready.
back to the issue of the mother and the father. So if the parents can prove, other than if they can both prove that they were dependents of the deceased person, then that might change the order in which so that order was talking about the father and then the mother.
Yeah.
If the mother can show that she was a dependent, she was depending on the son or the daughter, then that issue of who takes priority, whether it's the father or the mother, would not arise.
I see.
And then both of them can claim to be beneficiaries by virtue of being dependents.
I see. I see.
Yeah.
So I had just another curious question. In terms of being a potential beneficiary, you've listed father, mother, siblings, or either nephews and nieces of their siblings there. If all these, let's say for instance, if all these are not available, you said public trustee, is there anything like close friend who can become a potential beneficiary of this person?
Maybe I should clarify. I think this is the order of priority for petitioning and not really for inheritance. Inheritance comes in a different fashion altogether because it's about who is supposed to inherit. What if there's no one else and someone? So I think we should not mix up the issue
I
of
see.
priority
Yeah.
in terms of petitioning for letters of administration and priority in the sense of inheritance.
Inheritance, yeah.
Yes, so if it's about inheritance, I don't think we will talk of priority in terms of inheritance because that is a topic for, that is for the court's discretion upon application in court.
Oh, really? Okay.
The issue of inheritance, I think, is left to court after summons for
I
confirmation
see,
have
yeah.
been filed.
Yeah.
And whoever has petitioned has listed down the people that should inherit and their preferred mode of distribution. So if there is any dispute, whoever disputes files a protest, and then now the court actually looks at the application together with the protest and makes a decision in form of a ruling or judgment on how this property will be distributed. So in terms of priority, I would not talk about priority in the sense that one person has a higher right to inherit, but it's automatic that the children of a deceased person have
The highest.
a higher right, or will I say priority? Again,
It looks like we can't run away from that word.
I can't run away from that. Have priority, but once we are talking of the children, we will not say one child has, a higher right to inherit than the other. All children are the same.
The question was mostly on in a scenario where the deceased has no children and has no spouse. So that's why we were asking who happens to be the next most probable person to go next.
Like Council had said, I think we would talk of the parents.
The parents, yeah.
The siblings and step-siblings.
I see.
Yes.
Okay, thank you. Thank you.
I feel like I still want to belabor that point.
Yeah, sure.
I'm thinking about a situation where the father, say the mother or father is up country, and he or she runs her little business and is able to keep themselves. But this person that has passed on lived maybe with siblings in the city and was looking after them. Yeah? What happens in such a case? Because then the siblings look like they are the primary dependents and not the parent, literally by virtue of the fact that the parent is self-sustaining.
So I think the best way of looking at that is when the application for administration has been made, and then we've gotten to the point where the distribution of the property is being considered by the court. If any of these people feel that they have a right to it, maybe because they were dependents, and they have not been provided for in the application, then, as my colleague has said, then you have a right to go and raise an issue in court. You can raise an objection and ask the court to consider your application to be considered a dependent of the deceased person and therefore entitled to a share of the estate. But some of these things will be considered on a case-by-case basis, especially if the dependents were not direct relatives.
I see.
They were not relatives of the deceased person. Yeah, because if the deceased person was taking care of his siblings, and he didn't have his own children, then already there's a way they can be taken care of. But and if he didn't have parents, so they are automatically the siblings are going to be like the people who take over the property. But if for any reason they are not in the list, then they can go and raise an objection and present evidence to court. So it's not just about going to say, oh, I'm entitled to this. You have to go there with evidence to show that I'm a dependent, or I was a dependent, and I'm entitled to a share of the estate. Yeah, but so for if the distribution is going to be done in the ordinary way, as Ruth has said, there's no priority given over one person. So the share given is equal. Yeah. So for a dependent, the court might rule that they are not entitled to a share of the property, but maybe some other reasonable provision can be made to take care of their interests. Yeah. So, but that's for the court now to decide on the basis of the evidence that is presented.
Would that be the same thing as we have? Sorry, did I cut you short?
No,
Sorry,
it's okay.
We have scenarios of where someone has their own children, but they are also taking care of their younger sibling. But then this person passes on, leaves children behind, and with this other sibling that they were taking care of. So really, this sibling was dependent on the deceased. When succession is happening, can they be included, or is that what you're saying? That can also be at the discretion of the court to consider that?
Yeah. The issue has to go to court, and then the people claiming they have to present a case to court and show the court why they are entitled to. Maybe even receive the same priority as the children of the deceased.
Yeah.
Yeah.
Okay.
But it doesn't also mean that they're going to get exactly what they.
Okay.
Yeah.
Okay. I see.
Yeah.
Okay, that sounds quite reasonable, right? Yeah.
And talking about dependents, I'm thinking about some Kenyans are really kind and generous and are moved by mercy. And say you come across a brilliant child who has done well but cannot afford to take themselves to school. And so you approach the parents and you want to support, and you've supported for a while, from 1, from 2, then at some point in from 3, you pass on. Or whichever level of education the person is, if the parents go to court and said, huyu mtoto alikuwa analelewa na ule mtu, and there's something to show because umelipa school fees tangu huyu mtoto alikuwa alijoin form 1, and now we do not know what to do. We want this family to look after this child. How would you deal with such a matter?
I think to respond to that question, it all depends, because there are people who you will find taking those children in, like some of the political figures or people that we know who have taken in children and actually adopted them, fostered them, then later adopted them. And in that circumstance, then if it's an official adoption, of course, these children will have the same rights as the children who are born within their marriage, you know, so they become like legal children of the person who has just adopted them. So in terms of inheritance, they get as the same as everybody else. They get equal shares like the children of the home. But now here's the situation where someone is actually taking care of a child and probably not providing for everything, just probably school fees or probably shopping when the person is going to school. So that is where, again, I would revert to what council said, reasonable provision. So someone, if that person is not included by the other larger family of the person who has passed on, because most of the times the successions are so acrimonious. There are people who do not believe if you're not a child of this person, you should get anything from the estate of their late father or something like that. So if you have such a situation, then you have to make that application. If it's a child under the age of 18, then the guardian makes an application for reasonable provision. If the person is well over, they can always make that application and claim dependency of the person who has passed on. So if they're able to prove their case well, then the court will definitely make reasonable provision for them. But if the court is not convinced and it reasons in a different manner, then it will say if that was an act of generosity, and it was just it was not, you know, it was not an obligation really. It was just something that you do for someone now and then unfortunately
and ends at that.
Yes.
Oh, I see. Wow. Okay. When it comes to intestate succession and polygamous families, how does that happen? Is there anything like priority is first given to the first wife, first children, and then the others come later? Or is it also like purely distributed equally? And how legally, how is that handled?
Unaonyesha nini? Marriage certificate yangu is dated this year. Wengine wamekuja juzi.
Wamekuja hawa ni watoto wa juzi juzi.
Ni watoto wa juzi juzi.
Vile mali imeingia. Yeah. How does that look like?
Do you remember the parable of the person who hired people to work, and then so he started. There are people he hired at I think 6 a.m. in the morning, others at 9, others at 12, others at 3 p.m. Not walilipwa the same. They all got the same money, and then the people who are hired early in the morning, they got angry.
Yeah.
They were asking him, why did you?
Yeah, huyo amekuja juzi.
Yeah, he just started the other day. I've worked longer than him.
I'm already feeling angry on behalf of those women.
Right?
Yeah.
You can see where they're coming from. Tumeleba, I have supported this person to get where they are at.
Tulikuwa tunagawana bus fare. Tukikutana pale Kencom.
Imagine.
Siku hizi proud unitana.
Yeah.
Hata hatujui tufanye nini nazo. That's when someone has walked in. What do you think?
I think there are two ways of looking at that issue. But you remember the answer Jesus gave when the people complained. It's my property, I will do it.
Jerry, you're not helping this
Okay. Let me help. Let me
And
try
I'm like,
to
it's
help.
such a comeback, I can't even argue with it. Because
No,
the
but
moment you say, Jesus, what did Jesus say?
no, but hiyo tu ni
No, it's okay.
hiyo tu ni by the way.
We get you.
So, in this case, then, number one, it doesn't matter. When it comes to inheritance, then all the children and the siblings of the different, with the different wives, they all have an equal share. On the issue of the wives, even them, I think wives, they get what? A life interest, yeah?
Yes.
Yeah. So they get a life interest, which means that if they were staying in the house, if the man had provided, let's say, different houses for each of the wives, then they have a life interest in that house until when they pass on or they get married. Then that house will go to the children. So that's one way of looking at it.
But please describe life interest. Like, how is that beneficial? If I'm not owning the property, How is that
I
beneficial?
think, yes, that's a very important point to buttress in the circumstances that women should know that when their husbands are dead, they do not get anything, absolutely. Anything that the husband got or had, other than personal effects and household goods. You know, those chairs, the TV, and
Mrs. Itaki, tafadhali, tell me something.
Like
Tell
those
me
ones-
something
those
those
nice.
ones are yours, absolutely.
Kiti.
Now, now
Nguo, masuti.
the
Na
challenge,
na TV yenye after a
Sure.
few
The
years.
the challenge. Yes.
it's not
Now
smart
let's talk
anymore.
about land, where the man was
Yeah.
about the person
Yeah.
probably had properties, the land and all that. Well, that becomes a challenge because most of the times, and I've seen, you know, we have the law as is, and then we have the law as it's practiced. So you'll find because rarely do we even have much say as lawyers. Even
Oh,
sometimes,
really? In such a
even
situation?
actually, you advise, and people say, "Oh, you know, I can get somebody who can do it this way, my way." So you know, but the law is clear on that. As a woman, your husband has passed on. He left some properties. Those properties do not belong to you as a wife. You will not say you are inheriting your husband's property for yourself and to sell as you wish without the consent of your children. You get a life interest. What a life interest means is that you can only enjoy those properties as long as you are alive.
And
Yeah.
unmarried.
And basically what it means is that you're
And
not allowed.
unmarried. Ebu ongeza hapo.
You're
And
not
unmarried.
and unmarried.
Oh my
Because
goodness.
once you marry, your right is extinguished. So your children can actually go to court, petition, and say, "My mom got married, and we had done a succession. We had given her my dad's property, and now since she's married, we want that property transferred to ourselves because she's now married. Her right is now extinguished."
Yeah.
And then something else, the common mistakes we find people making are that people will get the life interests, and rarely, and I think it's a practice that the courts also need to adopt, is a situation where when we are issuing the certificate of confirmations of grant and we are giving property to the widow, can we kindly put life interest in brackets so that people do not assume
Yes.
that
yes.
since the title deed is in the
I
names of
see.
this lady,
Yeah.
it has absolutely.
Because I was going to ask,
Yeah.
in case of a title deed,
Yes.
whose name is on the title deed?
It's the name of the wife. She will get it. She will get
That's a
that.
loophole
But
there.
you see, the law says
Yeah.
she only gets a life interest. But since it's not clear, because
It's not indicated,
rarely do
yeah.
we even indicate.
Yeah.
Rarely do we indicate. We just write. In fact, you will find many people making these applications for confirmations. They only write absolutely. And the court should be clear because most of the times, people are not aware. They're
Yeah,
not aware
yeah.
because they're not aware that the wife only gets.
I
Yeah.
mean, the moment I see my name on a title deed,
Yeah.
the
You
assumption
think it's
is
yours, absolutely.
I fully own the property. There isn't an argument.
So this is the catch when it comes to life interest. You can still dispose.
oh,
There's
can
an
you?
exception, yeah?
Uh-huh.
You can dispose, but not unilaterally.
What does that mean?
It means that you don't do it by yourself without the consultation with your children. If you have children who are over 18, they have to consent and probably sign a consent to that sale and consent to everything
I
concerning.
see,
They
I
don't
see.
raise any questions as to that, and that's the exception.
I see,
Consent
I
of
see.
the children, because
I
those
see.
children are the ones who are supposed to get it absolutely. Yeah.
And if
Yeah.
the children are under 18, you can go to court
Yeah.
and you make it's an expert application you
For
make before a
guardianship.
judge, and you are allowed to dispose of someone. But you also have to have reason. You have
have
to
to
give
have
good,
reason.
you have to
Of
give
why you
reasons
want
why
to
you are
dispose
disposing of
it.
the
I
property.
see.
Maybe it's to pay fees.
Necessaries, yeah.
Yeah, just to
okay.
So you can't dispose it for your benefit.
like
It
that.
has to be for the benefit of the
Yeah.
Of the
children.
family, on
Of
the,
the
the
family.
children there.
Yes.
Children.
Okay, would you then guys say that's why it's important? Because this scenario is applicable to a situation where a will wasn't written, right? Would you say that's one of the reasons why it's important to have a will ready?
Yes.
Because if the
Yes.
woman is included in the will, that cannot be contested if it's done well, right?
Sure.
Okay, I see.
Agreed. Let me just say one more thing about that. So my feeling, in my thinking, there's still a way I think women can get around that.
Please
where,
tell us.
where they were involved in the acquisition of this property. I think there's a way they can go to court and make a case that this is matrimonial property, or a portion of it, or a percentage of it is, or sorry, they can make a case that this is a matrimonial property and they are entitled to a share. So that whatever it is that is going to be inherited by other people, then their share remains intact. So that share is theirs. It's like it's their property. So that whatever is now put up for distribution to beneficiaries it excludes the whatever the court has decided is theirs by virtue of it being matrimonial property. And by that I mean property that she can prove that she helped in the acquisition of. Yeah.
I see.
Yeah.
I'm
Okay.
seeing a conflict there, Jasmine, between the word of God and the law. Because really the word of God says that you're married until death do you part. But if I'm really that of the world, I'll then, I'm feeling like the woman will still remain just so that they don't lose that life interest. So it's like you're still tied. You sort of can't move on
Yeah.
on account of,
I've got property here and I
yet
need to enjoy
the
the
word of
interest
God
and
has
stuff.
released
Yeah.
someone.
Has set you
And I
free
don't
from
even
it.
want to ask a question. Does the man lose life interest? I'm not asking. I'm not asking.
Well, you've
upon
asked. That's
remarriage.
a good. I think it's a good question. Yeah. Does the man lose it?
Uh, does a spouse acquire? I think, okay, the way I've seen it applied, I think I'll need to do some more reading on this.
Okay.
Yeah, but
Fair.
it seems like the life interest issue applies to.
The woman
To
only.
the
The
woman
woman,
only.
yeah.
The
I
law
was
is
going to
not,
ask that.
it's
yeah.
not express
Yeah.
about the man losing anything.
Okay.
It's not express. And in fact, those are some of the pointers that have been raised by some feminists who claim that that is a bit discriminatory on women because that does not affect men per se, as we speak, because it's not express. So it's assumed it does not exist. So we have so many laws that, like we say, are a bit, we need to have changed or amended
Streamlined, yeah.
to reflect the
Yeah.
situation as is today. Like I've had somebody ask the same question on the Marriage Act 2014, when we allowed men to marry more than 3 women under the African customary law. I also had a woman ask, were we also allowed to marry more than one man? So when you ask that question, it's even offending to some people. So
Yeah.
What is good for the goose is good,
Yes.
good for the
so,
gander.
so now it's I don't know if we can equalize men and women at the same time, because we also come from a different cultural background.
Even mentioning it doesn't
It sounds
sound
offensive
right.
to some people.
Yeah.
Exactly, and your
Yeah.
women saying
Yeah.
that. So
I
clearly.
know, yeah.
So when this interest is being granted to the woman and they say you can only own it up until this time and this is what you can do with it and stuff, is there like a backing up reason that says this is the reason we are doing this, or it's just stated in the constitution, that's it and that's how we move on with life?
Oh, it's not in the constitution.
It's not in the
fortunately.
Okay.
It's in the law. It's in
Okay,
what
okay.
we call statute law, which
I
is
see.
below the constitution.
Below the constitution. Okay.
Which of course, means that there's still room for maybe the court to
Amendment, yeah.
make some changes.
Yes,
Or
okay.
maybe strike some of those provisions
I
as being
see.
unconstitutional
I
and
see.
things like that. Yeah.
Okay, probably some good news there. Yeah, some hope there.
Yeah. There's room for leveling of the playing ground.
I see. And then when it comes to the issue of intestate succession and stuff, when we say property inheritance, other than land, what else can be inherited?
So under the constitution, there's a very interesting definition of property, and it's like the way property is described there or defined. It's like it includes anything that somebody can have an interest in. So it's not just property like tangible property or real property like land or houses. It's anything which is intangible, which is inchoate, and it includes money. So it includes what M-Pesa accounts, it includes shares, it includes interest in I don't know, like in a circle. Yeah, so it includes M-Pesa if you have a healthy M-Pesa balance. Yeah, so it includes intellectual property, which includes things like copyright in music or in books or in films or things like that. So anything that somebody can have an interest in is can be inherited.
Oh, it can be considered as inheritance. Okay. When it comes, let's talk about the process of intestate succession. How does that look like? How is it done and all that?
Okay, let me answer that one.
Please go.
So, intestate succession starts with the process of petitioning. So we petition using we have standard forms that we have that are supposed to be filled in. We have the petition itself for letters of administration intestate. We have the affidavit in support of the petition. We have sureties. You're supposed to appoint at least 2 people to oversee your administration of that estate to ensure that you do the right thing and you do not waste the property. So we call them sureties, and they're supposed to be 2, and hopefully not beneficiaries, just 2 who are maybe your friends, your neighbors, people who are just going to overlook. The same way you go to a bank and get a guarantor.
Yeah.
something
Okay.
like that,
Yes. Yeah.
So we have that. Then we have an affidavit in support of the ability of those guarantors to actually overlook the administration. And then the consent. The consent is a consent by beneficiaries. Beneficiaries are people who are supposed to inherit. And normally, how do we know who the beneficiaries are? Every time someone passes away, we always send people to the local area chiefs, or where you come from, where you live, your area. So the chief will write a letter. The letter is called just a letter listing the beneficiaries. He says that he knows so and so, he passed on when he was domiciled in this and this place, and he left behind number 1, so and so, who is a widow, number 2, like that, and lists them in a chronological order, and writes at the side there their ID numbers. If they are minors, it will be indicated, and it say that daughter, son, and all that. If a person is a minor, the persons who are supposed to petition are supposed to be not less than 2 administrators, but the maximum we can do are 4 administrators at any given case. So we appoint 2 administrators if we have a minor, meaning a person under the age of 18. If there is no person under the age of 18, even 1 administrator can petition. When they petition, they're supposed to serve something called a citation to everybody who has been listed on that letter from the chief, meaning that this person has a right to petition, and they're being asked, I have requested to be appointed as an administrator. Do you have any objection to me being appointed by the court as an administrator? So that's the purpose of a citation. So if someone fails to respond to that citation, which is normally about 15 to 30 days sometimes, the person fails to respond to that citation, then the court will assume you have no problem. And of course, there has to be evidence of service. Evidence of service, we use something called an affidavit of service to say that indeed you went and took this citation to this person, and they either accepted or refused. Now, those are cases where we do not have a consent from these specific people that you are citing, yeah? But if there's a consent, we make people fill the form called a P&A 38, where we list them down, and they sign their consent to appointment of an administrator. So if they have consented, there's no need for a citation. The consent works. You take the documents to court, you petition, they go through the process of gazettement to the Kenya Gazette. You wait for the requisite number of days, which is usually the period between, yes, the Gazette notice, the Kenya Gazette notice. Yes, we give, the Kenya Gazette notice is given. I think we have to wait for around, I think, would say 30 days. It's 3 months, eh?
90 days.
And then the notice, after the notice period, after the notice period has expired, then you will be able now to, the court will actually issue something we call the letters of administration. So after the letters of administration have been issued, then now after 6 months, you can now make an application for confirmation of grant.
I see.
Yes.
Okay.
I've not gone over and above.
I think the Gazette notice, it's actually 3 months
It's
notice.
3 months, that is 90 days.
90 days,
yeah.
yes.
90 days from the date of gazettement and to the date that you're supposed to be, to the time the court actually grants the letters of administration.
I see.
Yeah.
Right,
I
thank
want
you.
to go back. I'd like to go back a little to. That was complex. I won't lie. Let me simplify. Let me
I didn't
simplify it for
intend it to be complex.
I've taken notes. But let me simplify it for myself and say, back to our original, our first question. A person, young or old, has died without a family and doesn't have a will. And according to what you said, the property reverts to one of the parents. In this case, let me put it as the father, so that it's simple. Tell us what the father ought to do. In simple terms, afanye tu nini.
Okay.
That process, simplify it
Okay.
nicely.
So I think if people came now to the law firm and asked for advice on what to do, I think the first thing I would tell them to do is, first of all, they need to find a way of getting a complete list of all the assets of the person who has died. And if there's also a way of finding out what his liabilities or his or her liabilities were,
Okay.
then also get that. Then also do a list of all the relatives, all the people who are related to this person. Then the next thing would be to advise them now to convene a family meeting, where you have all the beneficiaries in one sitting, and then you discuss how the succession is going to be done. So that's when now we start looking into who is going to be an administrator of the estate. So as Ruth has said, it's a minimum of 2 people, maximum of 4 people. So if the family can agree amongst themselves, then it makes things easier. Yeah. So they agree who the administrators will be, and then the administrators need to be also advised that being an administrator does not give you any priority over any of the beneficiaries.
see.
Yeah, in
Okay.
fact, the work of an administrator is set out in the law. Yeah, and it's actually quite delicate work because they have to ensure that the property of the deceased person is handled properly and in accordance with the wishes of the beneficiaries. So, and I think there are even some accounts that need to be done on a regular basis. Though I think many people don't do this, but there are actually obligations that come with being an administrator. Yeah. So once the administrator has been agreed, then you also look for the people who are going to be the guarantors or the sureties, and then now you start now the lawyer can help now with the process that Ruth has taken us through. Yeah. The lawyer can now help with all the filling in the petition and all the other affidavits that need to be done, and all the other applications.
I see.
Yeah.
All right. Okay.
Thank
You know, I have a question here from one of us who is joining us online. And it's a little bit different from our topic for today about a situation where there was no will that was written, but in relation to last week's. And her question is, say a friend is part of the will, and this comes as a surprise to the family. Can the family members petition against the friend getting any benefits? So this person was included in the will.
Well, they're not a direct, they're not a family member.
They are not family members, but they were included in the will. Do the family members have a right to go and petition against that?
Exactly, and that's why we always say that sometimes, like someone said, where there's a will, there's a war. So where someone has put in someone and other people are not so happy with that. The question is, have they all been catered for? Have they all been provided for? If they have, then they have no say in terms of how
I
someone
see.
has chosen who. In fact, people even give contributions, who even bequeath shares to animal orphanages, even companies and children homes. It's not unheard of. It's absolutely normal. So even a friend can get something,
I see.
as long as all the actual beneficiaries have been taken care of.
Okay,
Yeah.
I see. So it's not that
That's not a basis
I
for
see.
questioning a
I
will, the
see.
validity of a will.
Okay,
Yeah.
okay. As long as
As long as
the
everyone is
rightful
catered for.
is catered for,
Yeah.
I see.
Yeah,
All right.
you'll even see wills where maybe the person had a favorite person who was working for them,
Yeah.
maybe in the house or in in a company. Yeah, you leave them something, you bequeath them something, it's a sign of appreciation for what they meant to you in your life. Yeah.
But I'm listening to you, and I'm wondering if I've done a will, that's my will. You understand?
Yeah.
I'm wondering why anyone would come and contest what I have done, because there's a reason. I wouldn't. There's a reason why I've
I did it
indicated
the way I
that
did it,
name.
yeah.
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 And I know, long time ago, I don't know if it still happens now. Long time ago, I think parents would, the word is not even disinherit, they would fail to bequeath some children that were unruly. I think long time ago that would happen. I don't know that it would happen anymore, because then people can go to court. But I'm wondering, then doesn't that nullify the place for a will if it will be
Yeah.
contested?
I think, again, some of these things, it's on a case-by-case basis. So if somebody feels that they have been disinherited and they have a claim, then they can go to court and make a case for the court to overturn the will and make a provision for them. But
Yeah.
there's no guarantee that the court will side with you. The court might still say this is a valid will. It's too bad that this person didn't feel like leaving you anything. So as I said, yeah, some of these things are on a case-by-case basis.
I
Yeah.
see. All right.
Yeah.
Wow.
So,
Thank you.
yes, actually, to add on to what Council has said, it is indeed true that if children are unruly, and sometimes, most of the times, you'll find most people will not put in their will children who are probably beating them up. You have children who even beat their own aged parents,
Yeah. Yeah.
and they are so mad, and they say, "You'll never get anything from me." And they even decide to do a will just to make sure that this person does not get anything from their estate. And by the time this person is doing it, you find that they have even made reports and complaints to the police station. They have, everybody in the neighborhood knows that this child was actually not in good terms with the parents. All that is evidence. All that is evidence
I
that
see.
can be used in court, such
Yeah.
that if this person went to court seeking reasonable provision, the court will simply look at the evidence that is presented, probably by the other family members. They will
Yeah.
even present the neighbors, they will present the OB numbers where this person was actually making complaints. And the court will actually say, you know what? We are convinced why this person refused to put you in their will.
Yeah. Yeah.
And indeed, we will not change the will of a deceased person to suit what you want, because this is what the person wants. So their will should be respected. And we have reasons to believe that this person refused to put you there for a reason. So that being said, that will still be valid. Now, we also have situations where a person has killed somebody. Because you find we have seen instances where children are like, why are our parents living so long? Why can't they just die?
Wow.
So that we can inherit. Unasikia sometimes people are saying wamekalia vitu zetu. Why
Wow.
can't they just go?
Yeah.
So you'll find some of these kids even go to the extent of actually killing
They can
their
plot
parents.
against the parents.
Yeah, not just we've seen situations where they actually kill. They don't even hire anyone to kill their parents. They kill them themselves, and then after killing their parents, they start claiming inheritance. Well, that is clear even under Section 96 of the Act. It says that if you have even been mentioned, you've even been charged with the murder of this person, forget about inheriting from that person.
Oh, really?
Yes.
Okay.
So forget about
fairly so.
inheritance.
Yeah.
So definitely, you, even if you're a child of that person and you're not inheriting anything.
I see.
Yeah.
Wow. Wow.
So, children, honor your mother and father so that it may go well with you,
As the Bible comments.
as the Bible says, but also you may lose that inheritance.
You will lose
Yeah.
it.
And rightfully
true.
so,
Yeah.
honestly. You know,
Wow.
some parents like to, long ago, I'm quoting long ago, I'm not for long ago, but I know a few things. Some parents would just say, work hard and get your own things. These ones are for my wife and myself. And I think that's why they would say so that children also get that
Yeah.
stamina for working for
For working
themselves.
for themselves. That's true.
You know?
That's true. Yeah.
Yeah.
Yeah. Wow. All right. Thank you. Thank you so much, guys, for joining us today and for your meaningful contribution. It's always a joy to get to do this. It's it sounds like a complex thing, but really very important. It's right in front of us. These are family feuds we are dealing with. So wills are an important part of our lives. So we appreciate your contribution, your time, and your knowledge and wisdom that you've shared with us today. So asanteni sana for coming.
Is there time to say one last thing?
Sure.
So,
Sure, it's in.
I think there's something we didn't say last week when we were talking about wills, and which we didn't say today when we were talking about intestate succession, and that is before the will has been read and before administrators have been appointed, what can be done with the property of the person who has passed on. And the law is very clear that it is a crime for any person who has not been given authority by the court to dispose of the property of a deceased person. So this is why it's important that before family members start dealing with the property of
Yeah.
somebody who has died, they need to make sure that they have gone to court and they have gotten the requisite permission
Yes.
through necessary court orders, and or if there's a will, that the will has been read, and that the proper person under the will, the executor, is the one undertaking the disposition of the property. Yeah, so I just thought
Yeah,
maybe that's an important point to note
absolutely.
before
Asante.
we. Yeah.
Asante sana for sharing.
Let me just ask, because Jerry, people may not take land and sell it. That is cumbersome. But people may access bank accounts. What would you say about that?
In fact, for banking institutions, okay, actually even accessing money in a bank is a process. So I think banks have fail-safe procedures to ensure that only the owner of the money can access the property. And if the person is dead, then the bank will find out sooner or later. And when they do, then they should not allow that money to be accessed without letters of administration or without a will, showing that the person accessing the account has the right to do that. Yeah.
Sorry, one last question. So so it's there may not be will, but there may be a basic death certificate. What would you say about that?
Oh yeah, so the death certificate is one of the pieces of evidence you will need to
present.
help the court determine that actually, oh yeah, before you even start the intestate succession process, you have to prove that the person is dead. Yeah, there are people who actually fake death certificates and take out fake letters of administration. Yeah, but you have, so the death certificate is just evidence that this person has died, but it is not evidence of who is supposed to dispose of the property.
Yeah.
That has to be done through a proper legal process. Yeah, and somebody has to have the authority of the court to do that.
Yeah.
So, sorry, let me just wind this up. So the person gets a death certificate, then now they start all this process we talked about.
The ones Ruth talked about.
Okay.
Yeah, so
Okay.
so you get the death certificate, you get the letter from the chief showing them, and then evidence of the property that the deceased owned.
Yeah.
And then birth certificates for the children, just to prove, and marriage
the
certificate and
IDs.
things like that. So those now just make it easier for the court when it's making the determination during intestate succession.
Yeah.
Yeah.
Wow. All right.
Thank
So
you,
those will be
thank you.
part of the affidavits that will be
Yeah.
presented by the petitioner. Yeah, for letters of administration.
Wow.
Thank you for that
Asante.
clarification.
Asante sana. Thank you for clarifying that. And that's a good addition because again it's happening. So
Even as we finish, since that has been raised, I think people should also be very clear on the value of the estate of the deceased person. Our courts usually are divided or are, what will I say? They are, we have something called jurisdiction. So jurisdiction means the powers that a court has is limited. The only court with unlimited powers is a high court. So the lower courts are all limited in terms of their powers, in terms of how much they can handle. When we start from this of the resident magistrates court, they are limited to their 7 million, you know. We have the senior resident magistrate, we have the principal magistrate, we have the senior principal, we have the chief magistrate. Chief magistrate is limited to 20 million value of the property. So if you have property that's above 20 million, do not risk filing a petition for letters of administration in a lower court. Because if you have someone who is protesting, that will be one of the grounds of attacking whatever you have obtained from that court. And the court will definitely nullify everything based on jurisdiction. And you have to do it afresh in a court with the jurisdiction.
Wow. Wow. Thank you so much, guys. Finally, the final thank you. And that's it from Homescapes Midweek Vibes. Guys, I keep inviting you for Homescapes. I hope you join us as well. Homescapes is on Friday. Today's Midweek Vibes. That's it today. Asanteni sana for joining us. Have a blessed week.
Thank you.
Bye. Thank you.